Well, hello, Lyric Armstrong, real estate agent and advocate. Okay, we're back. Judge Simpson, what's going on? All right, if you remember, we just got out of the name of the case. I think it was Johnson. I think it's Johnson that is one of the tenants, but there's three tenants. They're having rental issues. And, her attorney, Kim, she tried to take the blame for not having the amended answer to include her claim of inhabitability due to some of the issues with the unit. And she lost that one. But if you remember, they just said, okay, just said, I'm going to give you guys a recess for you to go back there and talk and see if you guys can come to some resolution with these matters so that, we don't have to set it for trial. And plaintiff's attorney was like, there's really no need for this. Can we just go ahead and set it for trial? And, whatever. And judge said, nope, got to have good faith. So if you didn't see that video, go check that video out. There's a lot of great things to be learned relative to who's responsible when the attorney doesn't put things in the pleading, even though the attorney is the legal scholar. And why are they responsible? And how is it so that they're not responsible or whatever, So go check out the video and find out. Right now, we're going to see what happens to the end of the matter, see if they actually settled. All right, Judge Simpson, we're ready. We're here. We're in court. We have liked the video already, so do me a favor, like, share, and subscribe so that everyone can get the update. What's the update, Judge?
Are we on that?
Where are we on?
Come on up.
All right, Miss Kim, did you win?
Well, Your Honor, I wish we had good news, but I guess, are going to trial on all three cases. And Your Honor, I would request, I'm going on a long trip with my mother for her 80th birthday for most of October, I'm afraid. So I would request a date in November if possible.
See, no, what Miss Kim did is she brought up mom. And see,
Well, moms are important.
I know that. And that's the only time I bend my rules.
My only reluctance is, and I would have no objections to a November date, but the tenants aren't paying their escrow,
Well, Your Honor,
are not paying their rent.
that is not true, Your Honor. Ms. McClure's rent is zero. And Ms. Johnson has always paid her escrow, and she paid September rent actually to Forest Knoll instead of to escrow. Ms. Johnson. And so Ms. Jones is the only one behind in escrow, and she's willing to pay October rent into escrow.
Ms. Jones is the one who got spicy in the end, and judge said, you better tell her how to act in my court.
And maybe even September to ensure that we get a date further out.
All right.
I just confirmed.
I just want to make sure.
October,
Miss
September.
Johnson, I have 2 payments into escrow.
That should
in
be
July
July,
and
August,
August.
and then September was paid to Forest Knoll.
For Jones or for
Johnson.
Johnson?
Johnson, you just confirmed with me.
Yeah, no, she's talking about Jones. I think.
No, he's
No,
talking
I'm talking
about
about
Johnson.
Oh, yeah, she did pay.
She,
Right.
so
Yeah.
that one,
It's okay.
we're okay.
Ashley
And
Jones,
then
I think,
on
is the issue.
McClure, she's at 0.
She's at zero.
That's okay.
So he just said the problem was the tenants are not paying the rent. 2 of the tenants are, and the third one is not. So pay attention, man.
And that one's okay. So then it's Miss Jones. And
Miss Jones. And this is why you
I
don't
have
get
a
spicy.
payment of $1,200.
This is why you don't disrespect the court, because now you're the one that's the problem child. Gosh, come on. Let's go back.
I have a payment of $1,200
Okay.
in July.
That is correct.
August, September.
And as I stated, Your Honor, she
No.
is able to put October rent into escrow.
August, September.
What about
Which is how
August,
much?
September, October?
If you recall, Your Honor, there was this whole issue of the plaintiff stating that she was no longer eligible for subsidy altogether because she made too much income. And so Ms. Jones thought she had to move. And so she was having to make some decisions with 4 children.
I don't like Miss Kim's unfold. Like, I don't know. Like, what? So basically, she didn't have money. She can't do it. But why say it that way? Why not say she lost her subsidy, and since she was used to her subsidy, she didn't have the money coming in from the subsidy, so she doesn't have those funds. She's now in a position finally to make payments when she wasn't before because she was being subsidized. The way she says it is weird, but
Okay.
doesn't have it.
But that still doesn't tell me what happened to the escrow money.
She didn't pay it. She don't have it.
Yeah, you didn't get an answer. So, okay, here's going to be the problem.
Let me try.
We may get 2 trial dates then, because on Jones, I mean, everybody else is complying, so I don't mind putting that one into November to try to see what you guys do. But seems to me on Jones, I don't know why I wouldn't set it the next 14 days.
No. Can I say something? No. Who's that?
Mm.
Who are you?
I guess you did.
What? This is why I hate when it's in court. It's better on Zoom because we can kind of follow along a little bit. Who said what and what? That must have been Miss Jones. Obviously, she's the only one who cares to say something, but that didn't look like her. I don't think that she was African
Mind
American.
putting that one into November to try to see what you guys do. But seems to me on Jones, I don't know why I wouldn't set it the next 14 days.
Can I say something?
Mm.
I guess you did.
What did she say?
State your name.
Oh, Ashley Jones.
Okay.
Okay, thank you.
Oh. I'm just saying I applied for a rental relief program. I do have 4 children. Before they told me that I wasn't eligible and that I was gonna have to move because I was over qualified to live there. So I thought I had to move. So I'm trying to make arrangements because like I said, I do have 4 kids. And then now they're telling me you owe 987, but that was after, well, when I signed the lease, I didn't know at first. So basically it's all a whole bunch of confusion and I'm just stuck. But I mean, I don't mind paying the past balances that I owe, but I thought I had to move because they told me that I was overqualified to live there. More than once.
What back balance that you owe? What do you
No,
mean
I'm saying
by
for the
that?
past months that I have to pay into escrow.
Oh, okay. So you
I-
say you don't have a problem catching up escrow.
No, I just thought I had to move. So if I have to move, then why would I pay into anything if I have to?
Because the
Maybe.
court told you
All
to.
right. So I have escrow at 1453.
Well, Your Honor, what had happened was that they were charging her market rent, but when they actually recertified her, they realized that her rent was only 9 something.
All right. So I have August, September, and then upcoming October. What's the escrow amount? You guys
So the
can't,
statute
you
says,
guys can't agree on
the
anything.
statute says reasonable rent. You've ordered what the rent is at the reasonable rate, and we would say that that's what she needs to pay until there's a motion to amend it.
No.
Your Honor,
I make the motion to
I would like to
amend.
move to amend the escrow order.
Exactly.
They had,
You guys can't agree on anything.
Your Honor, I try to be reasonable, but her rental rate is not at market as they stated she was. And I
So
think they will
what
admit to that.
do you think her rental rate?
My rent is 987.
987.
Okay, hold on. And you think, Mr. Hughes, she's at market at the,
She's not.
No, I'm saying that you ordered escrow payment. I don't know when she went to when did she go to 90?
good, ask somebody.
When did she go to 987? I can't. When did it change?
Man,
Where's the file? Look at the recertification doc in the file. It tells you when.
That's 987 is fine. As long as it's paid promptly.
all right, so,
I am so done.
okay.
Oh boy.
So if I take 987 for 3 months, I come to 2961. So
Which months?
when are
August,
you
September,
gonna put
October?
that, when are you gonna put 2961 into escrow?
Well, I should have it off by the end of next month,
By when?
by the middle of next month. Sometimes my dad's day. I have 4 kids. I'm not even gonna.
Central had the other
Your
ones
Honor,
right then, too.
Your Honor, 2,961 is for 4 months, but you didn't deduct the 1,200 already in escrow, correct?
We won't deduct it because the rent didn't change until after that date.
No, but 1,200 is not a rent.
So, The
wanted to
statute
make
doesn't
sure.
say rent, it says reasonable rent.
Well, you just
And the
said
judge-
987 was.
I agreed with it.
So have you ever heard that attorneys can never agree? This is it right here. It doesn't say rent. It's just reasonable rent. Rent, reasonable rent. What you talking about?
That date.
No, but 1,200 is not a rent.
So, The
wanted to
statute
make
doesn't
sure.
say rent, it says reasonable rent.
Well, you just
And the
said
judge-
987 was.
I agreed with it
Okay.
going forward, not retroactive.
Get like a third wheel on a date.
Uh, Your Honor, I
I have 3 months, basically. Well, right now I have 2 months of escrow because I have August and September that need to be paid.
Thank you. August, September. And so he was doing 3 months for October at 9,
So when can that be paid?
whatever. 7.
Let's just go with, what was the amount, 987?
987 times 2.
Times 3.
I think it's 1,974.
1974.
Yes, I can still do math.
2 weeks.
2 weeks.
So that can be paid by October 3rd, and then October will be by when? I need a new ROA. That's kind of right here.
Yeah.
Your Honor, Ms. Jones states that if she's given 2 extra weeks after that, she could pay October.
Without late fee? Okay. Right.
Gonna pay that by October 3rd. And October's rent
Okay.
by the 17th.
Okay, thank you, Your Honor. What day in November can we meet?
All right, real good. So we've worked that out. And then when do So October's out. We need a trial date in November.
Before Thanksgiving.
About November 7th.
I can do trials November 7th.
I think we should have different trial dates. The two easier ones, McClure and Johnson, we should have on one date, and the complicated one, Jones, on another date. That would take much.
Oh, the rudeness, the shade. Oh, and Johnson is already in a situation where she's not controlling her expressions as much as she should be. And he is just poking at her.
We should have on one date, and the complicated one, Jones, on another date. That would take much longer.
All right. So what do I do? What do I do? then?
Objective characterization by counsel.
McClure and Johnson, why don't I set non-jury trials for the 7th of November?
And so when is she gonna have to pay November's rent into escrow? Now we're,
And I'll just set them both at 9.
But not,
Yeah, but clear your day because I have that discovery thing.
everything. I'm not taking care of the discoverable answers.
That will do those two. And then what date? What do we do?
November 14th.
All right. Then I'll set this one November 14th for non-jury trial.
Now that it's all to pay escrow, 987 for the first.
All right, thank you, Your Honor.
All right, thank you. This one,
Judge, the 14th date, I think that's going to work. I'm supposed to go to Tunisia for 2 weeks and through Thanksgiving, but I think I'm going to cancel due to Crystal's health.
okay,
But I'll let you know.
yeah, let council know and then we'll get you a new date.
Thanks, Judge.
Thank you.
Thank you.
Okay, well, wishes to Crystal.
That's it?
Just
Really?
probably his wife.
We actually made it through. Okay, 14A stands in recess.
Oh, okay. What did we learn? Okay, okay, here's a good thing for you to have known, to learn. As we said in the previous video, there are responsibilities, and yes, attorneys are the legal scholars, but it does not mean that they are God. They don't know it all, and they're still human. So in the human aspect of things, they may make mistakes. Now, you say, well, why do I hire an attorney? Because they are professionals and they do have the ability to do professional things. But even a professional doing professional things will require your input. You're going to have to give them the information they need to work with. So if you never tell them something they don't know, then they don't know what to do with it. And it comes up in discovery, and it could be a problem, or it may not be a problem. This particular circumstance, there's three defendants, seemingly represented by the same person. And seems like certain facts may have been confused, but at the very least, they were omitted in the answer. And it is affecting one of those litigants, disparagingly so, because, you know, she doesn't have the defense that she would have had that been in the answer, because she wasn't allowed to amend due to the delay. So we found that out in the other video. But in this video, one of the things we've learned that's very important, not sure why Madam Jones was not informed of this, but when you are in court as a litigant, as a tenant, and the judge has ordered you to do something, that's what you do. It's not an option. We find out in a whole nother video that someone just might go, you know, to jail thinking that they don't have to do those wonderful things required of them through the order of the court. We saw in the D. Warner probate matter that Dale Warner has gone to court twice, gone to jail twice now, because he has not complied with different orders. The first was civil contempt, and the latest one was criminal contempt. If you didn't see that, go check that out. Dale goes to jail. We had that video too. So the orders of the court put forth, they're not suggestions. The communications we have here, these are suggestions. This is my commentary. It's based upon my experience, based upon my opinion. It is not my advice. It's my commentary, right? So it's suggestive. You go to your state, you find someone, you need someone, you can ask me, I can refer you to someone. I have people all throughout the nation that I can refer you to. But nonetheless, you go to the professional to do professional and get the actual advice. However, I don't know why. I don't know how. I don't even know if. But what I will tell you this is when the judge says do, then that's what you do. And when the judge told her to put money into escrow each month at a certain amount, that's what she was supposed to do. And the defense of, well, they said I had to get out, so I wasn't going to put money into escrow and I had to leave. Why would I do that? That's not a defense. And quite actually, you're thinking you're doing something against the landlord when in fact you're breaking the law by not doing the order the judge gave you. So you let it ride. But do not follow in that footstep, because you just might get called into contempt because you didn't follow the order. If you do in fact get to a position, we did learn this, and you're in a position, then escrow has been ordered for $1,500 or whatever it was, and it turns out your certification says that you only should be paying $900, whatever it is. When you get into that position, you tell your attorney immediately so that the attorney can put a motion to amend the escrow amount. And then that way the judge can amend the order to have the escrow amount changed to reflect the actual rent it should be. So plaintiff's attorney, who was very honoring and quite snippy, and quite rude, really, to Ms. Johnson, calling her her case difficult, the difficult one. That is disparaging and poor characterization and just just honoring for no reason, other than the fact that they don't get along. But relative to the case, it's not difficult to know that she doesn't want to pay for something she doesn't have to pay for. So she wants to know that she has to pay for it. That's not difficult. She might be a little difficult, but that's not difficult, right? He had some good points in the fact that reasonable rent, it does not mean. And so I was playing a little game with that because that's just the lawyer in life. The word is the word, and you're gonna latch onto it like it's the Bible word, right? Reasonable. And his point was the judge came to the conclusion, and after doing his fact finding, he found that what was considered reasonable rent was higher amount, 1,500. And so that the motion to amend is not retroactive, but should be for the future to what this certification rate. And so that little play was what we do. We play with the words, and he was playing with. He was kind of snooty and snippy about it, but that was his job. He was doing his job. So on the other side, he did pretty good. He lost the argument in the end, but it's a good argument to make. And quite honestly, where he may lose it this time, he could very well win it next time. So it is a good argument that can probably survive other circumstances and situations. Okay. So keep that in your knowledge belt as well. So now that you're all knowledgeable and you know all these great things, instead of having to tell someone about it and another person, have 20 million different conversations, just have one. Click share and let everyone learn for themselves so that we all can learn together. All right. Like, share, and subscribe. I'm Lyric Armstrong, the real estate agent and advocate. And I'm hoping you are having a blessed one and not finding yourself in court. But if you do, please go get that professional, get an attorney, work with them throughout the case. Remember, there's more than just you, so help them stay reminded about the details of your case so that you can succeed and hopefully get a good resolution. Alrighty, I'll see you next time.